Great. Good morning. This is the Joint Legislative Management Committee meeting on November 29th, 2023. I hope everyone had a lovely and restful holiday. We are going to kick off our meeting with an update and continued discussion around our State House renovations. We'll then move to our legislative budget review for our branch, and then if we have time, hopefully we can review two HR policies from Arlene. So with that, if I could have Janet Miller come on up. Morning, everybody. Good morning. Janet.
Sorry, we're all on this end of the table.
Janet Miller, Sergeant at Arms. And so I just want to give you a brief update on where we stand with the mitigation feasibility study. Right now, we're looking to have this study back to us and approved by Friday, hopefully. And so then we'll be able to send it on to all of you. If we're just going to see if we can make any changes, then we might need a little time to do that. The next steps now for this short-term renovations to address the public health and safety would be the new atrium that we had all been talking about. And it would be the northwest elevator and the egress stairs for the Senate chamber. So this is all considered an addition to the building, even though it's not huge additions, but it is something different. It'll be kind of in the back, kind of on in between. So if agreed upon, as part of the process to move forward, the JLMC may want to work with the Friends of the State House, the curator, historic preservation, buildings and general services, myself and our consultant, Tricia Harper, and we can collaborate on providing the public with the proposed plan and the opportunity for public comment at this point, because it is considered a little bit of an addition. Then we can also, that would help give the corrections committees that information of how to proceed. And the approval for this program hopefully can be in the first few weeks of session so that the next phase of schematic design can move forward so that we can do this in a timely manner. These are the updates I have, and I didn't know, maybe Representative Emmons can comment on the schematic design phase, but that's all I have. So if there's any other questions.
So, Janet, it sounds like we're going to need another meeting to review the update.
Right.
Okay. Right. Okay.
And then make the next decision of how you want to go forward with the public comment.
And it sounds like 2 weeks.
Yeah, that would be good.
Members, at the end of the meeting, we'll regroup to find a date for another meeting to review this, because we need to really keep this conversation moving and going.
Right.
Does anyone have any questions for Janet? Or Representative Emmons, if you have anything to add, please don't hesitate to chime in.
No, this is helpful. And for folks who aren't aware, you need to go into a schematic design so that you really know what the project is starting to look like. And at schematic design, you also start to have a base for the cost of it. So it's really a preliminary design before you get to final design. So a schematic design gives you a base that you can then move forward. You can make decisions at that point to change a little bit. And again, you have a better feel for what the cost of the project would be.
Great. Any questions?
Thank you.
Thank you. All right, so stay tuned with that continued conversation. Next, we'll bring up Catherine and Scott with the legislative budgets.
So can I just interrupt? Are we done with this portion? Because I'm not part of the management committee.
That's right. You are free to go, Representative Emmons.
Okay, great.
Nice to see you.
Thank you.
Take care.
Good morning. I'm Catherine Benham with the Joint Fiscal Office, and I wanted to introduce Scott Moore, who I think you have met before. He is now the legislative finance manager in charge of one of his many roles is managing the legislative budget, and he is here to present it to you as part of the statute. And let him take it away.
Good morning, everyone. For the record, Scott Moore, Joint Fiscal Office. First of all, I did want to just extend my gratitude to all the different department heads. I spent the past couple of weeks meeting with everyone, and they've been gracious enough to answer all of my questions, so they've gone through the budget and compared all the things to build it up from the ground up kind of a thing. They answered lots and lots of my questions because I was new to the legislative budget. So with that said, hopefully you all have a copy of the memo I sent in front of you.
Yes.
And Mike can post it online. Thank you, Mike. Appreciate it. So I thought I'd just go through this and then take questions as they come up. So I'm on page 1. The first part, of course, just talks about what the committee will be focused on for this part of the budget. Then we get to the bottom part, looking at what the base was for FY24, which was $20,659,000, not quite $21 million. And then the proposed budget for FY25 is $22.2 million. And that differential is about $1.6 million change, or approximately 7.84%. Then part of the proposal is to revert some of the carry forward money back. And if we revert back $813,000, that would bring the total percent change for the increase down to 3.9%. Turn to page 2, kind of talk about what the big changes were. So realistically, most of the change was due to providing people costs. There's an increase in healthcare benefits, there's an increase in salaries, all those other things that were part of things that we had to absorb, quite frankly. The federal government increased the lodging rate. So that increase also is part of this, about 70% of the budget. So just bringing people here to Montpelier to do the job. And the other 30% part of the increase is basically some new asks that the different department heads had for some things that were new for FY25. And I detail those here, the FY25 staffing requests. There is currently a vacant position that's in legislative council that they would like to convert over to human resources. And that particular position would effectively do the role of HR specific things that currently all those different things are being absorbed by members of Ledge Council and the Director of Human Resources right now. So it's not a new position, it's just converting a position from one department to another. And there's also currently a Capitol Police Officer vacant position. And then the proposal would take that position and convert it to a sergeant position, which would have money associated with it, of course. And that would provide some additional supervisory coverage for longer periods of time during the day. And again, that's not a new position, it's just converting a position. And then there are 2 session-only law clerk positions, and part of the proposal is to convert those 2 into one year-round full-time exempt position. So that would be considered a new position. And then there's also one other request for a new audiovisual specialist in IT. So again, that would be a new position request. And those 4 requests are basically about 30% of the increase we saw on page 1. And then flipping over to page 3.
Scott, do you want us to, what's helpful for your presentation? Can we jump in with questions now?
Holler in anytime you want.
All right, Representative Shaw.
Thank you. Thank you, Scott, for this. That 30% of the increase is in 4 items. Do you have enough detail to be able to tell us, obviously, number 1, well, for me, it's obvious, but not to everybody, I guess. Number 1 is probably a neutral on dollars. But number 2, 3, and 4 have a cost to each one of them. Do you have that information anywhere?
Actually, I can tell you the dollar amounts for all 4 if you'd like.
That'd be great.
Sure. Number 1, because currently the position is not full, it would be about $173,000 to have salary and benefits for the midpoint range of hiring a new position.
Okay.
Number two, converting the Capitol Police Officer, that would have increased costs of about $42,000. And converting the two session only into one year-round full-time, it does have some savings because you have two session only, but then you have 1 year full round. It'd be about $47,000 total. And the last position with salary and benefits is $125,000. Add it all up, it's about $486,000 total, give or take. Well, absolutely. And I'm looking at page 3, just some of the budget pressures. I mentioned 70% of the increase is human, people related. There's increase in the healthcare costs. From fiscal year 24 to 25 is about 15% increase. That's a large part of that. There's also 3.9% salary increase based upon the Pay Act. The budget reimbursement for lodging is approximately 13% of that total 1.6 million. 13% is just the increase in lodging costs because of what the federal government has issued. There are some new payroll taxes that we have instituted that have not been charged in the past, including paid family medical leave and child care contribution. Like you can see here, the legislative expense reimbursements. It's $28 a night, which my first thought was $28 a night. That's not bad, but then 28 times 180 times how many nights? So it does add up pretty quick. And then there are some estimated internal service fund charges. I've been advised that those would be approximately 3%. That's not finalized yet, so that could go up a little bit. It could go down a little bit, but for the purposes of this budget, I put in 3% for an increase.
Same question, Joe.
Go ahead.
Same question, Scott,
Of course.
for these four items also. I just don't want to have to do the math.
That's not a problem. So if we look at number one, it is approximately, like I have it here in terms of percentages. Let me just see if I can rough out the math. I don't want to, I don't have a calculator, so don't hold me to the exact number, but for number one, it's approximately about $1.2 million of this 1.6 million. And then the new payroll taxes, that is not a huge, that's about $100,000 total. Legislative expense reimbursements just for that section is $201,000. Yep, give or take, just for the increase for lodging reimbursements. And internal fund fees are approximately $65,000 around.
Thank you.
Of course. Moving forward, we did discuss reverting some money to buy down that total 7.84% down to 3.5%. To make the math work, that total dollar amount would be $813,000 to get down to 3.9%. And here in this chart below, you can see the breakdown by legislative department. So the legislature, of course, includes the members. It includes House Clerk, Senate Secretary, leadership positions, Ledge Ops, Human Resources. So that first line under legislature does include 5 or 6 different subgroups, as it were. Here we can see that the breakdown for each, I'm happy to answer questions specifically, or I can read all the numbers, but essentially to get the 1.6 million increase, there's the breakdown by department. And then with the $813,000 reversion, that would bring us down to $805,000 more for FY24 than it was FY25 than it was FY24.
Representative Wood.
Thank you. Scott, could you tell us a little bit more about the source of the reversion? Is it vacancy savings? Is it, totally unfilled positions, less expenses than we were expecting?
It's a little bit of all of that. So the past couple of years, we have some vacancy savings, we have some of we spent less. So every year we have a little bit of carry forward from the year before. So the source of that reversion would be currently the carry forward that the legislative branch has.
And is this, this is my first year on this committee looking at this budget. So is this an unusually high amount? Is this the, relatively stable amount? Is this lower than previous years?
The budget itself or the reversion amount?
No, the reversion. I'm concerned about, in the out years then having a big jump in a succeeding year.
Yeah. Historically, what I've seen, this is higher than some reversions that I've seen in the past. I have seen reversions 600,000, 500,000. So I would say it's a little bit more, but it's not unprecedented.
Thank you.
There are other questions? Senator Kitchell, go ahead.
Well, just to pick up on Rep. Wood's comment, because, one of the things we're concerned about is those ongoing base obligations. And I was weighing this in terms of the instructions that other branches of government got and how we look. But when you really consider where the pressures are and the extent to which they are what you would more or less call uncontrollable, unless we want to reduce the size of the number of legislators or, like staffing, or where would you go to accommodate those increases? And so my concern is obviously carry forward is one time in nature, although that is indicative that in fact that there's some shuck within the base to accommodate ongoing expenditures. But it seems in the end, this is what is being asked for as it relates to the safety, as it relates to the technology to support the work of the legislature, and then just the very fact around the payroll and a reimbursement for expenses. There are not many places to go to say, is there any way of some offsetting savings for the, for the work that, or for the expenditures that have to be met. So I do think we're going to have to, obviously be careful about that, and in light of what other parts of government are having to do. But it did seem in the end, what's being proposed here, in light of the demands that are being placed on staff and the volume and the technology, that that these are necessary investments to support the work of this branch of government.
Thanks, Senator Kitchell. Are there other questions? Yep, Representative Shaw.
Thank you. May I ask a question?
Sure.
Capitol Police.
Sure.
Thanks.
Sure.
Morning, Kevin.
Good morning. Kevin Williamson from Director of Capitol.
So, Kevin, I want to talk about the conversion of a Capitol Police officer from an officer to a sergeant. So I'm thinking actually that could savings for you, because your Capitol Police officer might have to attend the academy, be certified. Is that true?
If I'm understanding the context of the question, by converting an existing position to sergeant, not having to send that person to the academy, is that the question?
Yes.
You are correct.
So we're saving some money there.
Yes.
$10,000 or whatever it happens to be. So the sergeant would come fully certified as a level 3 officer.
That is possible, or it could be a level 2. But yes, they would be already Vermont certified.
Okay. And I think I heard you say in a previous testimony that you wanted everybody to be level 3 in your department.
That is correct. That would be my desire, but that is not a requirement of law.
Right. So potentially at 42,000 could have some additional cost savings should the sergeant have a level 3.
Correct.
He wouldn't have to, that person wouldn't have to go through that.
Correct.
Okay. Would you anticipate that that hire would be a level 3 position?
Yes.
Okay. Thank you.
Thank you.
Thank you.
Excuse me.
Well, you're here. Representative Wood, go ahead.
Hi. I just wanted to double check to see if there were any other staffing changes recommended in this for the Capitol Police, and also to inquire about, does this budget include the vehicle that you spoke about in previous testimony?
Let me take the last part first. With respect to the vehicle, no, it does not. It's my understanding that there's been $15,000 allotted for a vehicle. That will not buy you a vehicle pretty much in the state. It will not. So I've got to look at other options. I need to discuss those with the sergeant at arms, but I've been researching it since our last meeting. One of my law enforcement colleagues suggested to me that I consider leasing instead of purchasing, but that requires some research to see if that is something that is feasible in this state. But he broke it down to me, explained to me why he did that at his department and how that benefited them, leasing instead of buying. The first part of your question was what again, ma'am?
Before I move back to the first part, so this budget includes the continuing 15,000, but nothing more. Is that what you're saying?
That is my understanding, correct.
Okay. So the other part of my question was whether or not there were any other personnel changes with regard to your budget.
No, ma'am. We do have vacancies that we're currently advertising for. But if your question relates to a request to increase the size of the department, the answer is no.
Okay, thank you.
Okay.
Go ahead, Senator Brock.
For the period that we're talking about, do we have an estimate of the rate of inflation generally?
I don't. I'm happy to go research and find out what the estimate might be, but that's not something I have prepared.
Well, I guess my concerns always, as I look at budgets like this, is we are spending on the basis of what we believe we need. Are we measuring that against any benchmark, such as what everybody else's expenses are increasing that have to pay for it?
We can get you that information.
And is this all in for all of the expenses associated with the legislative branch? For example, things like dues for NCSL and CFG, is all of that in there?
Yes. Yep. Senator Brock, that's part of all of each departmental budget has some other, aside from personnel, salary benefits, there's the dues, there's subscriptions to, for instance, from JFO, we have a subscription to Moody's for economic analytical research. So all that stuff is big.
Representative.
Can I ask Kevin a question about the IT? Is that possible? Oh, this Kevin, sorry, Kevin, yeah.
You're okay, you're okay.
Kevin Moore, Legislative IT.
Good morning, thank you. Could you just describe, because I am not well-versed in IT issues, and I certainly see potential need during the session. I know there's a lot of running around during the session trying to make sure that the equipment's all in order, and when it's not, the troubleshooting. Can you describe how this is going to be, what functions this serves during the year-round aspect of it?
Certainly. So this position during session will be largely maintenance and support. Low-level maintenance support, checking to make sure that systems are up and operational, that you run into fewer issues throughout the week. With the number of concurrent streams that we have coming out of this building, it's a challenge for our folks to go around and proactively check on all these systems. They do their best, but there's always a bug, as you've experienced in your committee room. During the off session, let me step back. In addition to those checks, maintenance and support, they will also be supplementing our existing customer service staff. So they will be doing regular IT, low-level IT support, password resets, things of that nature, all that transactional requests that come in. So it's a supplemental to our existing customer service staff. During the interim, they will be looking at firmware upgrades, configuration changes, structural changes, and updates to the systems that we have in place. We've built a pretty solid foundation of audiovisual within the organization, but it needs to improve. Our bar is for our systems tends to be higher. And so we see a lot of room for improvement in these systems. And we don't have that expertise on staff right now. We have tried to supplement with contractors over the last couple of years, and the response time doesn't meet our needs. The cost is usually substantially more than what we could otherwise do in-house. And bringing that level of expertise along with the ability to do user support, proactive maintenance and support during session will allow us to be more strategic about these upgrades rather than reactive.
Thank you. And then I'm presuming, since it wasn't highlighted here, that this doesn't include any major hardware investments.
It does not. What it does include is a 1/3 of our iPad fleet rolling replacement. That is, while this committee and the staff work to strategically plan what we want out of IT devices going forward. You saw a draft come around for other reasons not too long ago. Part of that draft is a discussion about legislator devices and where we want to go with that. But in the short term, we do have a slowly failing population of our fleet of iPads throughout. We need to make sure that we have enough in stock to support all of you throughout the session.
So that's a stopgap measure while you determine what would be a future investment.
Correct. And we tend to use a rolling replacement model for a lot of our hardware, just to be more predictable about costs and make sure that we don't have any huge technology cliff or tech debt associated with our budgets.
Thank you.
Go ahead.
One more question from the other, Kevin.
Oh, sure.
Thank you.
Sorry about bringing you back up.
No, that's okay. Good morning.
So you had talked earlier in an earlier meeting about upgrading the medical alerts and panic buttons and all those types of devices because we're not in the current century with those. You have money included in the Sergeant at Arms budget to do that, or will we see another request later on?
It's included, yeah.
It's included, okay.
Chief, I'll try to do my best to describe, but it's called RAVE mobile, and essentially would be moving to an application that anybody can have on their phone. So that is part of the Sergeant at Arms budget on an ongoing basis.
All right, good to hear.
Go ahead.
Excuse me, I just would like to add that, so right now, we're in the process of trying to put this all together, and we're working with our IT department. That's where we are right now, to make sure that system is going to interact with these hard walls around here. And Kevin, we're going to be meeting soon with them about that, I believe.
Yes, we have some positive preliminary findings on the system. We have not wrapped up that report with applicants and Sergeant Arms yet. Hope to do so shortly.
Thank you.
Thank you.
Thank you. Are there any further questions for Scott or any of the directors? All right, so if members would go to page 4, this is we're going to move into motion land here, which is we need 5 different motions to go through this, to approve these changes and to approve the budget. So we'll start at the top. I have a motion to transfer a vacant position from Legislative Council to Human Resources.
So I'll start off.
Yes.
I would move to support the transfer of an existing vacant position from Legislative Council to the Human Resources Department for the purposes of hiring that new position in HR.
Thank you. Is there any further discussion? Seeing none, I will call the roll. Senator Baruth?
Yes.
Senator Brock?
Yes.
Senator Hashim,
Yes.
Senator Kitchell,
Yes.
Representative James,
Yes.
Representative Shaw,
Yes.
Representative Wood.
Yes.
I am a yes. Motion carries unanimously. Thank you. Let's go to number 2.
Well, I'll try that.
Go for it. Thank you.
I would move to support the conversion of a vacant Capitol Police Officer position to a sergeant position.
Thank you. Any further discussion on this motion? Seeing none, I'll call the roll. Senator Baruch,
Yes.
Senator Brock,
Yes.
Senator Hashim,
Yes.
Senator Kitchell,
Yes.
Representative James,
Yes.
Representative Shaw,
Yes.
Representative Wood.
Yes.
I am a yes. Motion carries unanimously. Thank you. Go to number 3. Representative James?
I would move to support the motion to consolidate 2 session-only positions to create 1 full-time exempt position for use by legislative council.
Thank you. Any further discussion on this motion? Seeing none, I'll call the roll. Senator Baruch,
Yes.
Senator Brock,
Yes.
Senator Hashim,
Yes.
Senator Kitchell,
Yes.
Representative James,
Yes.
Representative Shaw,
Yes.
Representative Wood,
Yes.
and I am a yes. Motion carries unanimously. Thank you. Move to number 4.
I would move to create 1 full-time exempt position for use by IT for an audio visual specialist.
Great, thank you. Is there any further discussion on this motion? Seeing none, we'll call the roll. Senator Baruch,
Yes.
Senator Brock,
Yes.
Senator Hashim,
Yes.
Senator Kitchell,
Yes.
Representative James,
Yes.
Representative Shaw,
Yes.
Representative Wood,
Yes.
and I am a yes. Motion carries unanimously. Let's move to number 5.
I would move to support the proposed FY 2025 legislative branch appropriations as presented to JLMC on November 29, 2023, and require that the chair and vice chair be notified of any substantial changes prior to the executive branch budget recommendation to determine whether formal review by the committee is necessary.
Thank you. Is there any further discussion on this motion? Seeing none, I will call the roll. Senator Baruch,
Yes.
Senator Brock,
Yes.
Senator Hashim,
Yes.
Senator Kitchell,
Yes.
Representative James,
Yes.
Representative Shaw,
Yes.
Representative Wood,
Yes.
and I am a yes. Motion carries unanimously. Thank you, everyone. Thank you, Scott and directors, for all your hard and great work on preparing these budgets. All right, let's now move to our human resources policy review. Good morning.
Good morning.
There.
I felt like I was in a high chair there.
Good morning, everyone. I'm Arlene Donovan, the Human Resources Director for the General Assembly. I have 2 policies to review for your consideration this morning. One of them is our staff COVID-19 policy. And actually, this is just merely for 2 very minor updates to an existing policy that we update periodically when there are changes with the CDC and the Vermont Department of Health. There are questions that arise over time. So the last time this particular policy, which is titled COVID-19 Notification and Return to Work, was updated was just around this time last year, and there have been some minor changes that we'd like to update. So if you all have it in front of you, I'm just looking at page 1 under the purpose and policy statement. And you'll see at the last sentence of the purpose and policy statement, we've added a small phrase, as applicable, as it refers to the face mask policy. So on occasion, we get questions, even now, regarding whether or not the legislative face mask policy is in place, it's mandated. So it is in place, but we added this phrase, as applicable, because currently the requirement for masks in committee rooms is only when the CDC rates are elevated here in Washington County. So this literally is just a minor housekeeping change. So we have it as applicable here. It's not always in effect. It just depends on what the rates are. And the second change to this policy is on page 3 under close contact guidance. So this is in reference to some of the CDC and Department of Health changes. So when someone is a close contact, they are referred in this policy back to the CDC and the Vermont Department of Health to follow the guidance. And the guidance is to test over a period of time, which changes on occasion. And it has been noticed by myself, by Sergeant at Arms, that sometimes when someone is a close contact, the guidance is a little bit unclear as to whether or not someone who is testing negative can still come to work. And so in order to clarify that, yes, someone who is a close contact who is testing negative, following the guidance of the Department of Health, that they don't have to stay home. They are able to come into the legislative workspace while they are testing negative, provided that they are wearing a mask. So that's come up several times over the last 6 months or so. So we just wanted to clarify that here in this policy. And those are the only 2 changes that we are asking you to review today.
Any questions? Give folks a minute. All right. Let's see. Why don't we have the vote on this policy, but then we can move on to the next one. So I'll give members just 1 more minute with this policy and then ask for a motion to adopt the new COVID-19 patient policy. Any questions? Motion, go ahead.
Sure, I would move that we adopt this modification of the COVID-19 notification under work policy.
Great, thank you. Any further discussion? Seeing none, I will call the roll. Senator Baruch?
Yes.
Senator Brock?
Yes.
Senator Christine?
Yes.
Senator Kitchell?
Yes.
Representative James?
Yes.
Representative Shaw?
Yes.
Representative Wood?
Yes.
And I am a yes. Motion carries unanimously. Thank you. All right, let's move on to the next one. Thank you.
Thank you. So the second policy is our confidentiality policy. This is a brand new policy. And just so that you have a little bit of background, policies that are created through the HR department follow a process. And so the process is to draft the policy in conjunction and collaboration with Ledge Counsel, who is most often Damien. So Damien helps us draft the policy, and then we work together with all of the office directors to make sure that it satisfies all of us, really. So it may take several occasions to meet, which it does typically, to make changes and edits that we're all comfortable with before it is presented to JLMC. So that is the same process that we followed for this particular policy as well. The topic of confidentiality comes up quite often, and the request for this policy has been raised to my office multiple times in the last few years since the office has been in place. It applies to our state legislative staff, our paid interns when we have them, and our pages because they are also on our payroll. All of our policies have a purpose and policy statement. So I'm right now at the top of page 1. And the purpose of this policy is basically due to the very nature of the confidential work that we all on staff have access to and other types of confidential information. It's critical that the information stay and remain confidential while we are working here. It also is important that it remain confidential when we separate employment from the General Assembly. And so under this policy, staff would be required to keep these communications and information confidential. So that's the purpose of the policy. Moving down on page 1, what would be considered confidential? What is confidential? Well, communications and information under this policy that are related to legislative matters are considered to be confidential unless one of these situations listed here occurs. So if the communication occurs in a public setting, such as a floor session, a committee meeting, or another meeting where members of the public can view and access the information, it would no longer be considered confidential. If the relevant legislator or committee indicates that the communication or information is not intended to be confidential, or if the communication is generally known to the public. So if it's in the media, on the news and print, paper, or whatever, it would no longer be confidential. On the other hand, communications and information that are not related to legislative matters are generally not considered confidential unless one of these situations occurs. So if the staff member knows or reasonably should know that the information should be confidential, then it would be confidential. If an individual participating in the communication or sharing of information indicates or asks that the information be confidential or remain confidential, or if there is an applicable law, a rule, a policy, or a guideline that requires the information to be kept confidential. For example, comes to mind a legal agreement of some sort, and I'm sure there are a host of others.
HIPAA is another good example. So healthcare information, ADA information when someone talks to you about a disability. And then for attorneys, we're governed by rules of professional conduct that require that attorney-client communications remain confidential unless the client waives that confidentiality. So there are a number of instances here where we come into laws that require confidentiality, particularly around personnel matters and so forth.
Go ahead. I'm just reading number 2. Is not intended to be confidential. So it's maybe easiest to give an example. So let's say I'm having a conversation with a JFO staff member about the financial implications of a bill. Do I need to say this is confidential? Are they presuming that that's confidential?
The presumption is because it relates to a legislative matter, the presumption is it's confidential unless one of those 3 applies. So the communication, you're communicating with the JFO member in a public meeting like this one. You indicate to them, now this isn't confidential, or you don't have to keep this confidential. That's another really clear one. Or the information's already generally known to the public. So for example, the governor's budget has come out. The JFO member, just because you discussed it with them, the governor's budget with them in relation to that legislative matter, they aren't suddenly bound by having to say, oh gosh, I can't discuss the governor's budget publicly. Obviously, that's public information. Anything private that you discuss with them, such as, here are my proposals to modify the budget or something like that, that would remain confidential, but the public information would not be confidential. So there are times when we have conversations where some of the information is very public, but then there are legislative proposals working in the background that people are working through, and to protect the ability of you to deliberate over those proposals without having public scrutiny while you're figuring out, is this a good idea? Is this something I want to bring forward? We keep that confidential until you're ready to present that publicly.
Okay. I appreciate that clarification. I'm not sure that that's always clear. It seems very clear with legislative counsel. It doesn't always seem clear with JFO. And that's helpful for me to understand about when to be explicit. I think it might be better to be explicit in some situations.
Clarity always helps. Training and practice always help. A lot of times in this building, there's gray area.
Yeah.
In all of our jobs in this building, there's gray area where it's difficult to know whether something is confidential or not. Oftentimes, I think all of us staff experience the instance where multiple members are working on the same issue, and you have to kind of compartmentalize in your brain, okay, this is something that I'm only working on with Representative Wood.
Yeah.
So that's confidential until she says you can talk to X, Y, and Z about this. And then sometimes we have to compartmentalize, okay, these 4 people, and so forth. But it's, and it does vary by issue, and it can get really complicated, especially when things are working through committees and the floor process.
Yeah.
So,
Thank you.
yep.
So I'm at the bottom of page 1. One thing that we did want to clarify, and have done so at the bottom of this first page, is that this policy does not in any way prohibit or restrict a staff member from reporting sexual harassment, discrimination, or any other violation of law to a supervisor or another appropriate member or authority. We want to make sure that people are continued to be encouraged to immediately report those types of situation, as we have always done. And we want them to assume otherwise in this policy. The next section, I'm on the top of page 2 now, protecting confidentiality of communications and information. This section refers to the fact that staff also under this policy need to ensure that any information in their possession is not left unattended or made accessible to anyone who should not have access to the information. So leaving notes out, leaving computers open for someone to read, or leaving notes where they can be accessed or whatnot would not be permitted or is not permitted. And in addition to that, staff members under the policy will also have the expectation to protect the confidentiality of electronic communications, including our text messages and our emails. Currently, the Office of IT has protocols in place that we follow, and this policy is not intended to change those protocols. We are still required under this policy to follow those protocols. The middle of the page, when may a staff member discuss or disclose something confidential? So there are situations where a staff member is permitted to disclose confidential information, especially with the types of work that we do here in the building. And the reasons are listed here. So when the disclosure is made to another staff member who is authorized to receive the communication, it's permissible. When the relevant legislator or committee has authorized the disclosure of the communication, which is what we were just discussing. When the relevant legislator or committee has publicly disclosed the information. When a staff member's supervisor has authorized the disclosure of the communication. When the information is generally known to the public through another source other than the staff member. And when the disclosure is required by law or the applicable rules of professional conduct that Damien was referring to. So this may be a situation, for instance, where someone's safety is at risk, or there's a possibility of injury or harm to them. In those cases, confidential information could be disclosed.
Yeah, so this would be like instances where there's a mandated reporting requirement law. We have policies here at the State House, for example, if you witness potential sexual harassment towards a minor, that you report that directly to the Capitol Police because of the potential for violations of law to occur around that and the need to protect the safety of minors in the building. There could also be instances, for example, as an attorney, where if someone discloses certain illegal activity to you, you may have instances where you're required to report that. So, but again, this is basically if there's a law that requires reporting. Other instances I can think of are like vulnerable adults, vulnerable elders, things like that, where we have mandated reporting requirements in law or mandated disclosure requirements, and this doesn't get you out of them. So basically, this section, the very end of it is to avoid what we've heard about in the press in recent years, where people have said, well, I had a confidentiality agreement, so I couldn't disclose that this illegal activity was occurring at the workplace. And we're saying that this confidentiality policy is not intended to do that to anyone. Are there any other questions?
Yeah, we have two, so we'll go Representative James and then Senator Kitchell.
Where or how does like FOIA fit in here? Is that not?
So FOIA, again, when we do FOIA, there are an enormous number of intricacies there, and I see Tucker has left, so he's our FOIA expert. But with FOIA, there are certain records that are designated as confidential by law, and others that are privileged. So attorney-client communications are one of those. And then there are other things that can be disclosed to the public. So every time we get a Public Records Act request, that's something that we review, Tucker reviews, with the individuals who are affected by that request, and they go through the communications and determine what's confidential and what has to be disclosed under the Public Records Act. So, but this doesn't change any of our requirements under the PRA.
Yeah.
So.
Thank you. Senator Kitchell.
As I'm reading this, it strikes me, my question is, are we really putting in writing and formalizing what our policies are? In other words, is this something new and part of our effort to really get ourselves in a better position around our policies? And is this a replacement, or is this something actually we're doing for the first time to formalize? Because certainly the discussion around, confidentiality requirements on the part of staff, not sharing, et cetera, that we've talked about. So my question is this an update, or is this an example of where we've not had anything formalized and we are now actually doing what we should be doing?
I think this is formalizing existing practice. And the effort was to clarify what has essentially been the way we as staff have been trained in our various offices, and then ensure that we're consistent across the board.
Okay, so it's actually taking something that has been sort of in practice, but putting into formal policy. My next question is, once we approve these policies, what is the mechanism by which we let the legislative membership and staff know?
So Arlene can speak to this a little bit too. I don't want to be the only person speaking. But the mechanism is staff are made aware through communications from their supervisors. Training on the policy would become part of onboarding and likely should become part of periodic staff training. Because there are a lot of gray areas where it's good to ask questions and have those discussions as staff. I know, my own experience, when I get into one of those sticky gray areas, I often find myself going down the hall to our director and deputy director to say, okay, so here's the situation. What do I do? Is this something where I should be disclosing or not? And we'll talk about that. And I'm sure that happens in the other offices too. But that's generally how these things are rolled out, is through first notification and then hopefully scheduling training, and we can get staff together and find time to do that. So, I'll speak to that.
Well, policies are only as good as people's knowledge and awareness. So that's why I was thinking that's kind of a crucial next step. I've kind of learned you don't necessarily assume something's going to happen.
Arlene, did you have anything to add before?
Yeah, no, I think it's an excellent point, and I completely agree. So we do roll out the policies to the staff, and with the help of the directors right now, just because of lack of bandwidth in the HR department, I rely on the directors to help me out with the training and the rollout of these policies. I am hoping that with the additional position in human resources, that will be part of the function of this new position. So hopefully down the road, we'll be able to have regular training for the staff on all of the policies. But right now they are part of orientation we meet with everyone, all of the new hires, and we go over all of the pertinent policies that they need to be aware of. We also have them on a shared site for employees that employees have access to. And we train new staff on that shared site as well, so they know where to access all of the policies.
And that shared site is something that members have access to as well. It's the one HR. Yeah, so that's where members can get it. And if it's a policy that is relevant or helpful for members to be made aware of, I know I've sent them out in my updates. I'm sure the Senate sends out in there, so that we'll get out to members as well. Senator Brock?
This policy applies to employees, and among employees are paid interns. The vast majority of interns we have are not paid. And they very often are exposed to confidential information. And it's perhaps just a warning to us that we don't really have any kind of formal orientation that specifically deals with the intricacies of confidentiality, although we tell them to keep confidential things that should be kept confidential, but we don't tell them necessarily in sufficient detail what they are. And so the question is, should you or should someone else, because it's not really probably an HR issue since they are volunteers, create something similar to this to ensure that our interns, our unpaid interns, our college students are aware of this and in effect sign off on it, agree to it.
Yeah, we did have that discussion in one of our meetings about the students who are here from the colleges. Primarily, our students are here from UVM. So I work very, very closely, as does the Sergeant at Arms. We work very closely with the liaison between the students and the UVM coordinator. So we work with them right around this time of year, actually, to coordinate their orientation. Both Eliza and I do present to that group regarding sexual harassment, discrimination, and we can certainly discuss confidentiality if this policy is approved. And the other thing that we discussed doing, that I've discussed with UVM specifically, is we have an MOU that will expire, not right now, but in the coming year, and we will be writing confidentiality parameters into that memorandum of understanding so that it will not only be part of their orientation for the students, but it will also be required as part of the school.
I think we have to be mindful of the fact that although the majority come from UVM, we have a lot of one-offs of students who come from here, there, and everywhere, and they're not all there to be dealt with in a single orientation session. So something in writing that they sign off on, a mini manual, something like that, to ensure that they get the information in a consistent way could be very useful.
Yeah, that's a good point.
One of the tricky things with the interns who, may come from a different college or university in the state, or even possibly, be coming to the state to work briefly with a member that they have a connection with, is that they're not employed by the General Assembly. So it's one of the challenges we have is our HR policies don't apply to them because they're not our employees. This has been a sort of an ongoing struggle as every member potentially can do things differently with their interns if they're doing interns who are outside of the formal State House program with UVM. And so that's just a challenge that we have, and we don't really have a way of enforcing a policy except for the member deciding that they no longer require the services of the intern and effectively dismissing them. But our Office of HR doesn't have any power to sort of require training or require them to sign something. So it might be more.
I think that I'm trying to make is that I think we need something. Because if you have people who are exposed to confidential information, they may want to do the right thing, but if we don't tell them what the right thing is, they don't know what to do. And that's the point of having something that is presented to them also by their sponsor, perhaps is the responsible person for doing that, that they have a responsibility to maintain confidentiality of the records in the same way that an employee would.
It's a good point, Senator, and I think what we could do in the meantime for this upcoming session is we could discuss who's the right office for it to come from, but to send a message to all members with this attached to say, we're working on formalizing a process for interns that come in outside of the regular programs, and we strongly encourage you to talk with your intern and to fill this out. Does that sound good?
It does.
Okay, we can do that. All right, you want to keep on going?
Okay, so just at the bottom of page 2, just briefly references that if a staff member shares confidential information with another staff member, then that person is also, or another person, that person is also required to keep the information confidential. And before disclosing confidential information to someone who is not a legislative staff member, the person who's disclosing the information must get the approval from the relevant legislator or committee or the staff member's supervisor, unless, of course, it's something like we discussed is required by law to disclose. So now I'm on page 3. We wanted to flag at the top of page 3 that the state code of ethics does prohibit staff members from using confidential information that they have access to be used for their own personal or financial gain or for the personal or financial gain of another person. So we wanted to make sure that it was noted here in this policy. As is commonly the case with policies, there is some standard language here about consequences if the policy should be violated. If the policy is violated, individuals are subject to discipline up to and including termination. And there is a confidentiality agreement that we also drafted that could go along with this policy that I will just review quickly with you in just a moment. But the confidentiality agreement would be required of legislative staff. And it states that they are required to maintain the confidentiality of communications that they have access to, not only while they're employed here, but also after they separate employment from the General Assembly.
It's important to note the agreement and the policy can stand without the agreement. So if this committee decides that it wants to move the policy, it doesn't have to move the agreement with it unless you decide that that's something you want to do. So this was prepared to give you options to consider. Many employers do require agreements, not all do. There are questions over enforcing them and so forth. So, and I'm happy to discuss that when we go through the agreement, but it's just important to note that even though this paragraph is in here, you could move the policy with this paragraph stripped out. So.
On the middle of page 3, conclusion of employment. So this section generally says that if a staff member leaves employment, they are required to turn any confidential information in their possession over to their supervisor. And if a director should leave, they are required to turn over any confidential information to their successor or another appropriate custodian who could be in charge of the record keeping. It again references that if a staff member leaves, they are required to maintain confidentiality of any communication under this policy. And then the last piece on page 3 is relative to the rules of professional conduct, which we've discussed applies to attorneys. There are special rules of confidentiality that they are held to. So this section talks about the fact that staff members who are subject to the rules of professional conduct are required to comply with those rules that require some greater protection of confidentiality. So there may be a higher level that they are held to, that they would need to follow, be required to follow. And those that require or permit disclosure of communications or information under certain specific circumstances. And the last piece actually carries over to the top of page 4. And it just talks about if there's a rule of professional conduct that conflicts with this policy, then the rule of professional conduct would prevail over the policy. The last piece of this policy under the bold line is standard language. You will find it on all of our HR policies. So it's just something that we put on everyone.
Any questions about the policy? We'll move on to the agreement after. Go ahead.
Not a question, just appreciation. I know it was tough to take things that are understood generally, vaguely across the board and render them down into one very clear piece. So much appreciated.
Thank you. It takes the help of everybody here. We've met multiple times, as they would all attest to, I'm sure.
Yeah.
to get the work done. But,
Yeah, there's a lot of appreciation for all of the directors who went over this policy with us in excruciating detail at times. Emphasis on excruciating for all of us, I think.
we cover every base, I will say that. Okay, move on to so the agreement is just this single page here. It is a summary. I won't go through the entire thing. It's a summary of the policy that we just discussed. It would be, there's a signature requirement at the end of this policy for those it applies to. If an individual is a minor, we have a signature line here for their parent or guardian that would, in most cases, not all cases, refer to the pages and perhaps some other staff who are under the age of 18 or 18, under the age of 18. It basically says that they have reviewed the policy, they've received it, they understand it, they will abide by it. At the end of the agreement, it again emphasizes that they are not restricted from reporting anything that falls under harassment or discrimination or violation of law, and reiterates that the policy applies to them throughout their employment and after they separate from employment.
Yeah, I was just wondering, you mentioned this was optional. Are there other similar agreements that legislative staff are required to sign? Would this be one of 4 or one of 6 or?
So generally, and Arlene, I think, can speak to this a little bit more, but we have, we sign receipt of, for example, the sexual harassment policy and so forth. I can't think of any specific agreements that we sign, apart from like legislative IT, where we agree to return the laptop at the end of our employment, et cetera.
The state code of ethics.
State code of ethics.
Maybe not an agreement, but required to abide by them, understand them, read them. I'm trying to think if there's another like agreement other than ITs, which definitely is an agreement.
Yeah, we're all at-will employees, so none of us have employment contracts. Or at least no one that I'm aware of has an employment contract with the General Assembly. So we generally, and you've seen the boilerplate language at the end of all of these policies that says this doesn't establish a contract, which we put in there to maintain the at-will nature, since we all serve at the pleasure of the General Assembly.
I ask because if this were, for example, the only one or one of only 2, it sort of elevates the importance of this, right? So I would just want to make sure that we were doing that intentionally. Like, we're going to ask you to sign this because this is just as important as X, Y, or Z. And if this is the only one, then I would think we would just want to be intentionally saying, we're asking you to sign this because this is extra important. So I just wanted to make sure that there was thought around that.
I tend to like the idea of signing a confidentiality agreement. One, because it assures that the hiring supervisor has reviewed the policy with somebody. And, HR will be checking to see if they've received, a signed policy or not. And then, personally, I tend to remember things that I signed more so than things that I haven't signed. And so there is sort of I think, an elevated sense of accountability when we sign something. I was kind of wondering about the check boxes at the bottom. I was like, I just thought those were curious.
Probably more administrative for our purposes.
Oh.
There was on this page and they needed a guardian signature.
Okay, gotcha.
That's all.
Okay, all right.
Looking around the room for thoughts on whether to include the signing the agreement or other general questions. Go ahead, Representative Shaw.
So, David, what's the downside of having this document attached to the confidentiality?
So, the potential downside is it one can be discouraging for some people. They may not want to sign an agreement. They may not want to sign a contract that says, I agree to be bound by your confidentiality policy. There are some perceptions about these in the employment realm. There have been confidentiality policies and non-competition agreements and other similar policies in recent years that have put these in a bad light because they've been overly broad, overly restrictive. The one that always comes to mind for me is the non-competition agreement that a particular sandwich chain made their sandwich makers sign, which prevented them from taking their expertise in making sandwiches to any competitor in the area. As you can imagine, that's bordering on the ridiculous, but so there's that. The other downside to this is these are not necessarily easy to enforce. And if it's violated, you can't unring that bell. So if someone decides to violate it, you're left with a hard case to try to get basically damages for breach of contract. The information's already out there. The upside is that maybe it prevents a few more people from violating confidentiality. A policy question for you at this point is we haven't had one of these up to this point. And the question is, do you think we need this? So it does give you a tool in the toolbox to try to enforce confidentiality. The downside is that tool may have a chilling effect on some employees. It may actually not be as valuable a tool. Just because when you get to court, the questions start to arise, whether the agreement's reasonable, whether it's a reasonable restriction, what are you enforcing it for? And it costs money to litigate these things. And as we all know, the state has very limited money to be bringing these cases unless it's a really egregious breach of confidentiality. So then the question is, when are you enforcing it? So I think it's a mixed bag from a legal standpoint. These agreements are enforceable in Vermont, but they are only enforceable to the degree that the court believes they're reasonable. So if the court finds that the scope of the agreement is unreasonable to the extent you're trying to enforce it, the court will not enforce it. And it takes a lot of money and time to get to that point with the court. So you can probably only be seeking to enforce this in the most egregious situations. And then there are questions of, well,
So in this case, this is just backing up to be adopted the policy. This is just backing up the policy. Whether somebody signs the agreement or not, they're still, if they're an employee by the General Assembly, they're bound by it, the confidentiality.
Right. The policy already gives us the authority, the clear written authority. We have the authority regardless because we're at-will employees, but the clear written authority where you can basically say you knew there was a policy that said you have to keep confidentiality. You violated it. And that gives us grounds to terminate you immediately.
And that's what this document is.
That's what the policy is.
The policy is this, but this document affirms that.
What the agreement does is it affirms that, and it also affirms so the policy, we say this will apply after you're done working here, but when it's just policy, we have no teeth. There's nothing we can do to a former employee for violating a policy after they cease being an employee. When you've signed a confidentiality agreement, then you could potentially seek breach of contract damages from that employee. So it deters disclosure after employment. As I mentioned, the ability to enforce that, it's not as easy as just saying, we're bringing a lawsuit, because they're very difficult. And it's an area where there's not a lot of precedent in Vermont. And so what you'll be doing is basically, if you do try to enforce one of these, you're going to be basically covering new ground and trying to figure out with the court and the other party the extent to which it's reasonable. So that's my I guess very gray legal analysis of this, but the agreement really gives you teeth after employment that the policy can't give you. That's probably the biggest piece.
I see a couple hands, so we'll start with Senator Brewer.
Going back to receipt instances, so sexual harassment and ethics, I think you mentioned, where the employee signs that they've read and understood, as opposed to creating an agreement. Was that an option that you explored for confidentiality, and understood, given what Damien just said, that that wouldn't include the tool to use after somebody leaves our employ, but it would be maybe more in line with what we're currently doing with other policies? What would your thoughts be, recommendation-wise, on receipt versus creating an agreement?
I mean, I think, if we don't do the agreement, then you would be asking the employee to acknowledge that they've received and read it.
Yeah.
And, I think, as I mentioned in response to Representative Shaw, it's basically anytime you say I've received and read it, you're basically saying, okay, we're going to hold you accountable to this. And it's important to note too that there are breaches of confidentiality that occur that are inadvertent, they're minor. Nobody's going to lose their job or be penalized for that. And then there are, intentionally breaking confidentiality for some other reason where it's something egregious. That's potentially where you see discipline. And I can't think of an instance of that happening in my time here. But I'm also not privy to everything. That's basically, those are the instances where you can point to the policy and say, we've got the policy, we're going to pursue discipline and so forth. And that's what receipt gives you.
Yeah. And I think I understand that. I'm still wondering about a recommendation from both of you, one way or the other, because it seems to me, Damien, you laid out pretty carefully a balancing act, that there are pros and cons. With that said, which do you recommend to us? Do you recommend that we pursue this agreement, given that it's a new step, or is it just something you're laying out in case we want to go there, but you're not recommending?
And if you have different opinions, that's interesting as well.
I think I would weigh it more based on the legal aspect, to be honest, because yes, I think having someone sign a receipt or an acknowledgement that they've received something helps, right? Because at least we know that they're saying, yes, I've read it. There's a clause in here that says, yes, I can be terminated if I violate the policy or if I breach the policy. But again, from a legal perspective, I don't know how much weight it holds once somebody separates. And maybe that's where we are. That's what we need to be contemplating.
Yeah.
Yes.
So I'll just say that as a legislative attorney, I'm not used to recommending policy to the General Assembly. So I didn't come with a specific recommendation. I think and I'm gonna be very lawyerly about this, but my recommendation would be that if you're concerned about employees breaching confidentiality after they leave the General Assembly, that you consider the agreement. If you're not, I think the agreement potentially has a chilling effect on some staff members, and when you've got the policy, if you're not concerned about the post-employment disclosure, the policy gives you the tools you need.
Yeah, and I agree with you. I don't remember an instance of this happening. So I suppose my initial thought is, why go down the road of creating an agreement if we're not using those in other instances?
All right, so we have Senator Kitchell, then Representative James, and then Representative Wood.
So I wanted to go back to the comment about a chilling effect. If in fact we have this agreement, would it be a condition of hiring? And if someone said, no, I'm not willing to sign the agreement, then what would be the impact? Would we then not hire that individual? I'm just wondering in terms of what are those other collateral impacts? It seems like the issue is so much around after someone leaves employment and what you have for tools, but certainly, but I guess this option wouldn't achieve the same legal ends as something signed by that employee, as to having a checklist that for the hiring entity within the legislature to sign and confirm that, all these requirements or all these policies were discussed with that potential employee and signed and dated by that hiring entity. But my question is, what if we say, oh, well, we want this agreement, what would be the implications for someone saying, at the point of hiring, saying, I'm not willing to sign?
As it's written here, it is a condition of employment. So if someone refused to sign, we would not hire them.
Yeah, okay, so I just wanted to confirm that.
Yeah.
Do you have any other questions, Senator?
No, I guess legally it's a signed agreement as opposed to having the supervisor have a checklist and confirm that all the policies were discussed with the new hire.
Yeah, that's exactly what this is. And this would stand out because it would be the one contract that we would have for employees, so.
Yeah, and the other option is not a contract, so thank you.
All right, we'll go to Representative James, then Wood, then Senator Kashim.
Senator Kitchell may have answered my question. I assume when everybody is hired, they're given a policy manual and they sign that they've read and received it and they understand it all.
There is not currently a policy manual that they sign, but we do orient every person who comes in. So we're working on an orientation. That's part of what we're working on in HR. So we have multiple policies and we review them when they come on board as part of their onboarding. And eventually we will have a policy manual that they sign, but right now we discuss them all with them. So they're not signing anything in receipt of them at the moment.
You have a follow-up, or are you good?
But no, just that might be great and solve a lot. I mean, seems like that might be a good interim step or something.
Mm-hmm. Okay. Representative Wood?
So thank you, Damon, for sort of explaining what the import of this is or isn't. So after understanding that better, I'm not sure that violating confidentiality for me raises to the one and only, currently at least, status of employment, being accepted or not accepted. Some of us might think that the sexual harassment policy maybe is of great, I think people will disagree about whether or not this is the most important thing and whether to elevate it. That being said, I do think signing, acknowledging that you've read and received the policy, like we do for other things, I guess I'm more in favor of putting it at the same level as the other policies that we have, not elevating it to be something different and conditional.
Senator Hashim?
Thank you. So I just wanted to say that I am in support of having a signed confidentiality agreement. I know that, as was mentioned, we haven't seen something in the past that's been an egregious breach of confidentiality, but that doesn't necessarily mean that it won't happen in the future. And, we don't, I mean, if there's a breach that leads to a serious harm or injury of anyone who works here, I want to make sure that the tools are available to remedy that injury. So I'm in support of the signed agreement.
All right, any other questions? So I'm hearing a little mixed. Well, let's first go to the proposal here. Are there any further questions on this policy? Okay. Any concerns on this one? Okay, I'm not seeing concerns, so. Oh, go ahead.
I would just add that I share what Senator Hashim has said. I would be concerned if we don't take this seriously. It doesn't sound very important right now, but it will when something blows up. And that something could be something that damages a citizen who's entrusted us with confidential information that gets breached. It could be something related to a contract that has a financial implication to the state and to potential contractors. So there are a lot of things that can happen by virtue of a breach that we perhaps haven't thought through and talked through, but there's certainly enough experiences in the world where confidentiality breaches have damaged people. And I think the notion of having a signed document and having this in place is important.
Yes, so any other thoughts on the agreement? I'm wondering, and I'll put out for the committee to discuss, and Arlene, I don't know what the timing is, but would, for those who are feeling like we should have this signed page with it, if there is a plan moving forward to have something that's for everything, are you comfortable waiting for that to come into place, or do you think we should act now on this one? Because, and Arlene, could you tell us a little bit about the timeline on that, or if there is one yet?
I don't have one yet. I would love to have a timeline. I guess that said, I don't think it would be all that difficult to put some type of an agreement in place or something that somebody signs that says that they are in receipt, they know where to access the policies. I don't think that would be all that difficult to do. It's just a matter of, it really is more rollout than anything else, rolling it out to the staff at the beginning of session. New hires are easy because we meet with all of them.
Sure. Senator Brock and Hashim, would that feel like a good balance, or do you folks want to, and please, I'm hearing like less about the signature, but wanting some receipt, so that's where I'm trying to go.
Yeah, I'm comfortable with
that idea. You're okay with that? How about you, Senator?
Yep, I'm fine with that.
Okay. All right, so we can work on that path then, moving forward. I'm seeing head shaking, yes, yes. Go ahead.
I was wondering if you would entertain a motion to approve the policy.
Yes, I feel like we have moved to that place. Any further discussion? Go ahead.
Do we need to approve it, but strike out the confidentiality agreement paragraph for now on page 3?
Yeah, that would be the motion.
Yeah.
If you're approving the policy without an accompanying confidentiality agreement at this time, the motion would be to approve the policy with the language on, with the section entitled confidentiality agreement on page 3 struck.
So moved with the James/Leonard amendment.
Fantastic.
I'm uncomfortable with it.
All right, so this is a motion to approve the confidentiality policy, but striking that section out around the agreement. Is there any further discussion? Not, I will call the roll. Senator Bruce?
Yes.
Senator Brock?
Yes.
Senator Hashim?
Yes.
Senator Kitchell?
Yes.
Representative James?
Yes.
Representative Shaw,
Yes.
Representative Wood.
Yes.
I am a yes, motion carries. Thank you. All right, members, thank you, Damian and Arlene. Again, we know this took a lot of time and effort, and appreciate all your hard work going into this. Thank you. All right, so I'm just gonna quickly look at Janet Miller while I'm pulling out my calendar here. If folks could pull out their calendars, and we're just gonna go ahead and set up our next check-in, which is the focus on State House renovation conversation. Janet, do you think the 15th or the 18th would be appropriate timing, or do you? I think it could work. Okay, I'm looking around the table.
I
Friday.
can do either.
Either? I'm looking around.
I can't do the 15th or the 18th either.
Did you say can or can't?
I believe you said can't.
Oh,
Can't.
okay. Can't,
Yeah.
all right.
Yeah.
Let's see, who else? Kath? We have James?
I can be.
Your words say.
Because I use a calendar and I didn't bring mine.
Okay,
Oh.
sure. Looking around the table for,
The 15th is preferable, but I could rearrange a couple of things on the 18th.
I can't do the 18th.
okay. Senator Brock?
I have the 15th after 10:30 a.m.
Okay.
Morning meeting.
So 10:30 would work?
10:30 would work. 9:30, 10:30.
Okay.
10:30, I drive fast.
All right, so let's go with 10:30 on Friday, the 15th, and we'll check to make sure that Senator Ingalls and Representative Emmons can make that time. I know scheduling is just really challenging right now, and so it's going to be, Senator Kitchell, go ahead.
Yeah, 10:30, would we be done by noon? I have a periodontist appointment at 1 in Burlington. So
Yeah,
would
we
it take
can-
more than an hour and a half?
I hope not. I don't think so, but sometimes questions come up that spark conversation, but we can do our best to get you on the road.
Okay, all right. Then the 15th, the morning, and starting at 9?
10:30
No,
is.
10:30, I'm sorry, 10:30.
Yep.
I'll put that on my calendar.
Perfect. All right, thank you. All right, beautiful. Any other requests for agenda items or topics from the committee before we wrap up?
I'm just wondering about the hiring process for the.
The hiring committee is continuing to interview candidates, and when we go through that process for this committee, then we make a recommendation whether candidates move forward to the next round, and so we're in that.
It's still in the interviewing
Yeah.
process. Gotcha.
Yep. Right. Any other questions? Thoughts? Great. Meeting is adjourned. Thank you, everyone.